Thank you for joining us for another installment in our semi-annual series, You Have a Contract, Now What? You're joining us on day 3 of this 3-part installment. We started on Monday of this week with representatives from the Facilities Management Division who shared tips and best practices on how to be successful upon being awarded a contract with their agency. Yesterday, which was day 2, was the first of 2 presentations from the Broward County Attorney's Office, and we learned about Broward County's standard agreement terms and requirements, elements of a contract, and some flow down clauses that are in the prime vendor's agreement with Broward County that need to also be in their subsequent agreements with subcontractors and subconsultants. In case you're wondering, the information that will be shared today will have a different focus and cover different content than yesterday's session. Our presenters have an hour allotted for their presentations, and you'll have 30 minutes after the presentation is concluded to ask any questions and have them answered. To do so, you'll need to go ahead and click that Q&A button towards the bottom of your screen, and you'll be able to submit your questions, and we'll answer them during that 30-minute slot. And now, without further ado, I neglected to introduce myself, but you can see on the screen, I'm the Small Business Development Manager in the Office of Economic and Small Business Development. My name is Donna Ann Knapp, and it is my pleasure to introduce today's presenter, Mr. Fernando Amuchastegui, who is a Senior Assistant County Attorney with Broward County's Attorney's Office and has been advising Broward County Purchasing Division since 2018. He's an expert at what he does. He provides legal advice and support in connection with the procurement of goods, services, and construction. Fernando previously served as Deputy City Attorney with the City of Sunny Isles Beach for 10 years and is a graduate of the University of Miami School of Law. Mr. Amuchastegui, with that, I'll turn it over to you.
Thank you. Thank you for that warm introduction. So I'm going to be doing a presentation on the cone of silence, objections, protests and appeals, and suspensions and debarments. So these are issues that vendors may encounter at some point. Hopefully they don't encounter any of these issues. But the purpose of today's meeting is to go over these rules and regulations that govern doing business with Broward County, and all vendors should be aware of these requirements so that they don't run afoul of anything. So without further ado, I'd like to start with a presentation on the cone of silence. If we could please go to the next screen. So the cone of silence is found in the Broward County Code of Ordinances, and it's a period of time where the vendor or the representative who is seeking a contract award, a recommendation, or approval for a competitive solicitation, they're prohibited from communicating with county commissioners, county staff, and we'll go into what the definition of county staff, or the evaluation committee for the competitive solicitation. So basically, during this period, the vendor or the reps cannot contact these individuals within Broward County until the cone of silence ends. So we're going to go through when does the cone of silence start, when does it end, who's affected, and we'll be going that in the subsequent slide. So can we please go to the next slide? So the cone of silence, it applies to a competitive solicitation, and that is defined in the procurement code as an invitation to bid, an RFP, an RLI, or an RFQ. So we start with invitation to bid. All bidders, we have evaluation committees, but some of the procurements are done through what we call an invitation to bid. And an invitation to bid, it does not involve an evaluation committee. It's a form of a competitive solicitation in which price is the determinative factor. Assuming the vendor is otherwise responsive and responsible, whoever submits the lowest price is going to get that contract, which is in contrast to an evaluation committee-based procurement in which price is only one of several factors. And just because you submitted the lowest price in an EC-based procurement does not ensure you will get the award, even if you meet all the responsiveness and responsibility requirements. So RFP, this is typically the most popular form of a competitive solicitation. And that's when the county has to determine what specific goods or services it wishes to procure. It's determined that it's appropriate to procure these goods or services based on a combination of price, quality, experience of the vendor, or other factors. So in other words, price is not the only factor here. The county, the evaluation committee is going to look at a whole criteria of evaluation criteria. An RLI, so this is definitely a much more rare form of competitive solicitation. That's when the county wishes to obtain a solution, but it doesn't quite know how to get there. And so it's asking the vendors, hey, vendors, this is what we want. We want to obtain a solution, but we don't know exactly what type of solution. So they do what is called an RLI, a request for letters of interest. And then the whole goal is to select a vendor based on quality, experience of the vendor, and other factors identified in the solicitation. And RFQ, that's another form of competitive solicitation. That's where the county is getting information from vendors regarding their qualifications to provide the goods or services to the county. So can we go to the next slide, please? Okay, so again, we talked about the cone of silence, and it is it applies to a vendor or a vendor's representative. We've already gone through the definition and who it applies to. So the first thing is if a vendor or your rep, you cannot contact the commissioner office, a county staff, or evaluation committee while the cone of silence is in effect. So the first thing is what is meant by the commissioner office. That means that a vendor or their rep cannot contact a county commissioner or any staff member reporting to the county commissioner. The county staff means basically everyone in the county, unless you are one of these, unless you meet one of these exceptions here. So basically, do not contact county staff unless the county staff you are contacting happens to fall within one of these exceptions. And we make exceptions for employees of the purchasing division. So the vendor or the reps, yes, you can contact the purchasing division. You can also contact the designated project manager or their designee, as indicated in the competitive solicitation. You can also contact the small business development specialist supervisor, designated by the director of the Broward County Office of Economic and Small Business Development, to answer any questions regarding the competitive solicitation. You can also contact employees of the professional standards section of the Human Resources Division. You can also contact the chief financial officer, the county attorney's office. You can contact the county attorney's office and employees of the county auditor. So the groups that I just identified here, they are not considered quote unquote county staff during the time that the cone of silence is in effect. And now, of course, the exception is if those persons are voting members of the evaluation committee, then you definitely cannot contact them. So there are some rare occasions when you would have one of the members, for example, there was a recent procurement during one of the members of the county attorney's office was a voting member of an EC for a very specialized procurement. And so because they're a member of the EC, you cannot contact them. So just be very mindful of the definitions. And of course, the evaluation committee, this would only apply to an evaluation committee-based procurement. So this is not an invitation to bid. This would be like your RFP, your RLI, your RFQ. And in those situations, you have an evaluation committee. It includes a group of individuals who are appointed to serve on the evaluation committee to evaluate responses to a solicitation and or to rank or shortlist those responses. So the EC members, you can never contact them while the cone of silence is in effect. Next slide, please. Okay, so when does the cone of silence apply? Okay, so the cone of silence, so there's, except for unsolicited P3s, and a P3 is a public-private partnership. And again, that's kind of a rare solicitation. Just so everyone, I don't know if you know what a P3 is, but it's a public-private partnership. It's a contract between a public agency and a private entity that outlines how services and assets will be delivered. So it's often used in transportation projects, such as design, construction, finance, things like that. A P3 is definitely not it's definitely not a typical competitive solicitation, but it is covered by the cone of silence. So just be mindful of when the cone of silence starts. For the regular competitive solicitations that we talked about, the RFP, the RLI, the RFQ, ITB, that begins upon the advertisement of the competitive solicitation. So whenever purchasing advertises the competitive solicitation and it's advertised on an electronic bidding platform, it will indicate. So whenever the advertisement date is, that's when the cone of silence starts. So if there is a solicitation where it's like an unsolicited P3, like a vendor submits an unsolicited public-private partnership proposal, the cone of silence begins here. It's differently. If the vendor submits the proposal, it's whenever the county receives it, the proposal. For all other vendors, it's upon a decision by the county to advertise a competitive solicitation for that unsolicited P3. Next slide, please. Okay, so when does the cone of silence end? And this is very important. So the cone of silence terminates at the earliest of the following. So it's whenever the board or other award, so the award authority could also be the director of purchasing. Remember, if it's under 500,000, that's within the director of purchasing's award authority. But it's whenever the board or other award authority make a final award or approve the contract for a competitive solicitation, or if it rejects all bids or responses to the competitive solicitation, or if it takes other action that ends the competitive solicitation, or the time that the board, so obviously this only applies for an unsolicited P3, if the board determines not to advertise a competitive solicitation for the applicable unsolicited P3. So be mindful of this. When in doubt, read the cone of silence ordinance. It's set forth in section 1-266 of the Code of Ordinances. And we're happy to supply you with a copy of that ordinance. Next slide, please. Okay, so who is a vendor's representative? So the cone of silence not only applies to a vendor, but it also applies to their representative. And that means an owner, an individual, employee, partner, officer, or member of the board of directors of a vendor, or a consultant, lobbyist, or an actual potential subcontractor or subconsultant who's basically acting at the control of the vendor and communicating with the county regarding a competitive solicitation. So the cone of silence applies not just to you as a vendor, but also to any of your representatives as defined in the cone of silence. Next slide, please. Okay, so now there are exceptions to the cone of silence, like certain communications are permissible while the cone of silence is in effect. And so it's important to go over these exceptions. So if the vendor or the representatives are making presentations at a pre-bid conference or at a public meeting related to the competitive solicitation, of course, that's outside the cone of silence. Also, if the vendor or the rep are engaging in contract negotiations related to the competitive solicitation after notice of the proposed ranking or proposed award, that's also an exception. The third exception, making a presentation to the board of county commissioners, including responding to questions posed by the board during the public meeting of the board. So that would be at like a Broward County board meeting. If the item comes up, then yes, if you're presenting to the board, you're responding to questions, that's outside the cone of silence. Also, as indicated earlier, communicating with persons designated in the competitive solicitation as a contact person. So, I think we indicated that's a project manager or their designee. We also indicated you can also contact with the small business development specialist supervisor designated by OESBD to answer questions. You can also communicate in writing to the director of purchasing or their designee. We have some other, next slide, please. And as indicated previously, communicating with the county attorney's office or the county auditors, also communications between county employees or between a commissioner office and county employees, that's outside the cone of silence. This is an important point. The cone of silence is not two ways, meaning A commissioner office or a county staff can initiate contact with you, the vendor, or your representatives if they want to obtain additional information regarding the competitive solicitation, of course, other than an unsolicited P3. Or if the commissioner offices or county staff, if they want to get more information, or if they have questions regarding the vendor's response to the contact that was initiated by the commissioner office or the county staff. So again, it's impermissible for the vendor or the vendor's rep to initiate that communication, but it's okay if a commissioner office or a county staff, if they're the ones who initiate the communication with the vendor or the representative, if they just want to get more information from the competitive solicitation with regard to the vendor's proposal, and if they contact you, that's okay. So just understand that it's the cone of silence here is it's one way. It does not prohibit communications from commissioner office or county staff to you as the vendor, as long as the commissioner office or the county staff initiate that communication. But you can, okay, so I just wanted to make that point. And again, communications between employees of the professional standards and a vendor or their representative, that's permissible. And we already talked about if the vendor or the rep, if they contact the county attorney's office or the county auditor's office, that is permissible. That is permissible. Next slide, please. Okay, so what happens if there's a violation? So if there is, so let's say that it's discovered that one of the vendor or the representatives, let's say that they initiated communication with the commissioner office, county staff, or a member of the EC while the cone of silence was in effect, then somebody can file a complaint with the county's professional standards office. So if a complaint is filed, let's say that a vendor finds out that another vendor initiated contact, then they could report them to the professional standards. An investigation shall be performed, and the results of the investigation shall be set forth in a written report within 6 months after receipt of the complaint, unless the human resources division director determines that additional time is required. So let's say that there is a complaint referred to professional standards. It's determined that there's a violation. The corresponding fine for a first violation is $250. If it's a repeat violation, it's $500. Now, a vendor can appeal that decision regarding the cone of silence. And of course, that would go to, we're going to talk about the appeal process. But yes, if there is a finding of a violation, that decision can be appealed. Here's an important point. At the sole discretion of the board, a determination of violation shall render voidable any award of the applicable competitive solicitation to a vendor found to have violated the cone of silence. But remember, it's at the sole discretion of the board. But that is one of the potential consequences for violating the cone. Now, another important point, if a vendor is determined to have violated the cone of silence on 3 or more occasions within the prior 5-year period, the director of purchasing shall initiate debarment proceedings against the vendor pursuant to the procurement code. And we'll get into the suspension and debarment in a second. If we could, I just need to have a sip of water. Can we please go to the next slide? Okay, so now here's the other topic that I want to talk about. It's vendors. You have what we call your rights to object, to protest, and appeal certain decisions. And we're going to go over what can be objected, protested, and appealed. So for RFPs, RFQs, and RLIs, a vendor may object in writing to a proposed recommendation of ranking made by an evaluation committee. So an objection must be filed within 3 business days after the proposed recommendation of ranking. And again, we're talking about an evaluation committee-based procurement. So if there's a proposed recommended ranking, a vendor has the right to file an objection. Of course, I would refer you to section 21-42H of the procurement code. It's very detailed as to what requirements must be complied with if you're going to submit an objection, and you have to strictly comply with those requirements. Failure to timely and fully meet any requirement will result in the loss of a right to object. Okay, next slide, please. Right to protest. Okay, so the right to protest, you have that not only for evaluation committee-based procurements, but also for invitations to bid. So for ITBs, RFPs, RFQs, and RLIs, a vendor may protest specifications or requirements of a solicitation, or if there are specifications or requirements that are included in any addenda. So the protest must be received in writing by the Director of Purchasing within 5 business days after the applicable solicitation or addenda is posted on the Purchasing Division's website. For an invitation to bid, obviously remember there's no rankings to object or for an invitation bid. The vendors can only protest a recommendation for award made by the Broward County Purchasing Division. For RFPs, RFQs, and RLIs, vendors may protest a final recommendation of ranking made by an EC. So remember, for the committee-based procurements, you have the right to object a proposed ranking. Now you also have the right to protest final recommended ranking. But again, that must be done within 5 business days after the proposed recommended final ranking or recommendation for award is posted on the Purchasing Division website. Also, this is very important. Protests not only have to comply with the other requirements regarding protests, but they also have to include a filing fee if it's applicable. And if you don't include that filing fee or meet any of the other requirements of the protest, timely and fully meet those requirements, it will result in a loss of your protest rights. Next slide, please. Okay, so effective an objection or protest. Okay, so let's say that there is an objection or protest that's filed with respect to an EC's ranking. Okay, so if that occurs, the ranking must be submitted to the board for final approval. And the board has these options. Again, if there's an objection or protest, they can accept the ranking as final. They can reject all responses to the solicitation, or they can direct the EC to reconvene to consider any new or additional information that the board directs the EC to consider. In addition, the board may request presentations by the ranked vendors and may, by a supermajority vote, re-rank those vendors in a final ranking. So next slide, please. Okay, right of appeal. So a party who has received, if the vendor's received an adverse determination with respect to, and there's certain matters listed in the Procurement Code, section 21.81 of the Procurement Code, they may submit a written appeal of that determination to the Director of Purchasing. And what the Director of Purchasing would then do is transmit that for what we call an administrative hearing before the Department of Administrative Hearings in Tallahassee. So there's kind of like 2 avenues of appeal. So the first one here is heard by, we refer to them as DOA, the Department of Administrative Hearings. And the second one is if there is an appeal with respect to specifications or requirements of a solicitation, that is not appeal to DOA. That is actually appeal to the county administrator or their designee, who shall determine the method, timing, and process of the appeal, and whose decisions shall be final. Okay, so next slide, please. Okay, so when I indicated there's 2 paths for appeal, this is what I'm referring to. So let's say that let's say that a vendor, if you're found to be non-responsive, you have a direct right of appeal. And also, if you are protesting award or a ranking by the EC, that is going to go to the administrative law judge with the DOA. Now, if you're also for the debarment, the cone of silence. Now, for the debarment, cone of silence, and the vendor evaluation, the decision of the ALJ decision. So let's say we're going under the first path of responsiveness. Let's say you're found non-responsive, or let's say you're protesting the rankings. Okay, in that situation, it's an administrative. If you appeal that decision, then the Director of Purchasing forwards that appeal to the administrative law judge. Their decision is only a recommended order. It is not binding on the county. So the county administrator has the authority to either accept it, reject it, or modify it, and present it to the board for final decision. And then the vendor would be able to file an original action only after that final award or action by the board. Now, under the second path, so the debarment, cone of silence, or vendor evaluation ratings, under that second path, the administrative law judge's decision is binding, but it is subject to further review by filing an action in the circuit court for Broward County. Next slide, please. Okay, so we indicated earlier what matters may be appealed. So these are the issues that can be appealed under the procurement code. The first one we talked about, a determination regarding responsiveness. Okay, so that determination can be immediately appealed. The second one is the most common, would be a determination by the director of purchasing regarding a protest of a proposed award or ranking. C, a determination by the director of purchasing regarding debarment of a vendor or refusal to reinstate a debarred vendor. The other one is a determination by professional standards of a violation of a cone of silence, which I indicated earlier in the presentation. That decision can also be appealed. A vendor final performance evaluation with an overall score below 2.6, unless there is pending litigation between the vendor and the county relating to the contract at issue. That decision can be appealed. If a vendor files litigation against the county regarding such contract, after filing the appeal shall be deemed withdrawn by the vendor, effective upon filing of the litigation. So it gets a little complicated if there's a subsequent litigation action. Okay, next slide, please. Okay, so this is important. So the timing of the appeal is crucial. So if you wish to file an appeal of one of these decisions that we indicated, you have exactly 10 days after the date of the determination being appealed. And again, we talked about the filing fee. An appeal of the director of purchasing's determination regarding a protest of a proposed award or ranking, it must be accompanied by an appeal bond or a certified copy, an amount equal to 1% of the estimated contract or $7,500, whichever is less. However, if the estimated contract amount is less than $250,000, the bond shall be $2,500. Next slide, please. Okay, so right of appeal, if you are appealing a final performance evaluation, it must be accompanied by an appeal bond or a copy in the amount of $5,000, unless such appeal will be heard by an employee of the Office of the County Auditor, in which case no appeal bond is necessary. And of course, in lieu of an appeal bond or certified copy, the county will accept money order, certified check, or cashier's check, or other manner of payment approved by the director of purchasing in the required amount. Next slide, please. Okay, and this is the final topic I wanted to go over, suspension and debarment. Suspension or debarment. What are the causes for suspension? Well, it's easy. The director of purchasing may suspend a party when the director of purchasing has probable cause to debar the party. So the standard for suspension and debarment is essentially the same. So now let's look at what constitutes probable cause to debar a party. Next slide, please. Okay, so a party may be debarred, and obviously by definition suspended for any of the following. When a party or an officer, director, owner, member, partner, or management level employee of a party, if they're convicted of a criminal offense relating to obtaining or attempting to attain a public or private contract or a subcontract, or in the performance of a contract or subcontract. So if there is a criminal conviction, that may be grounds, that is potential grounds for debarment and also suspension. The next one, when a party or an officer, director, owner, member, partner, management level employee is convicted of a crime or embezzlement, theft, forgery, bribery, falsification, or destruction of records. You see the definition there: receiving stolen property or any other offense indicating a lack of business integrity or business honesty that seriously and directly affects their present responsibility as determined by the director of purchasing. Another potential ground is when a party is convicted, or an officer, director, owner, member, partner, management level employee is convicted under state or federal antitrust statutes relating to the submission of bids or proposals for a government contract. Next slide, please. when a party or an officer or director, owner, member, partner, management level employee violates the provisions of any contract with the county. So again, if you're found to have violated the contract, and if the violation is determined to be of a character that director of purchasing determines to justify debarment, including here, and these are the two important criteria. If there is found to be a deliberate failure without good cause to perform in accordance with contract specifications or within the times for performance required by the contract, or if there is a significant recent record of failure to perform or of unsatisfactory performance in accordance with the terms of the contract, provided that the failure to perform or unsatisfactory performance, it was not caused by acts that were beyond the reasonable control of the party. Again, another potential grounds would be failure of a vendor awarded the contract to provide the required bonds, insurance, or other certificates within 10 days after demand from the purchasing division. Next slide, please. These are some additional potential grounds for debarment and as indicated, also suspension. Refusal to accept a purchase order or execute a contract within 10 days after demand by the purchasing division, provided that the purchase order or contract conforms to the solicitation. Okay, so here's another potential ground. If you are suspended or debarred within the last 3 years by another entity of which the party's principals or officers were principals or officers at the time of the suspension or debarment, unless it can be shown by clear evidence that the suspension or debarment resulted from conduct that did not involve the principal or officer. Here, this is another potential ground: violation of ethical standards set forth in section 21.3 of the procurement code or otherwise under Florida law, or if there's a violation of the cone of silence on 3 or more occasions within the prior 5 years. So if you're found to have violated the cone of 3 or more times, you may be debarred. Next slide, please. Violations of fair dealing policy, that's set forth in the Code of Ordinances. Here's another ground. If a party receives 3 or more final performance evaluations over a 5-year period, and 3 or more of those overall evaluations were below 2.6, that's another potential ground. Here's another one. If a party makes material misrepresentations in responding to the solicitation, that's also potential grounds. Another one, if a party is debarred by another governmental entity, or, and this is the catch-all, any other cause the director of purchasing determines to be so serious and compelling as to affect the party's responsibility as a county vendor. Next slide, please. And we just a few more. I think we just went through this one. 28. Yeah, 29. Okay, there we go. So what is the effect of suspension or debarment? Okay, this is very important. If a party, so if the vendor is suspended or debarred, they may not respond to any county solicitation, nor may they be approved as a subcontractor on any county contract for the duration of the suspension or debarment. If an individual is suspended or debarred, the suspension or debarment shall extend to all entities for which the individual serves as an officer or principal. So that's another important thing to understand. Next slide, please. Here we go. So, all right, period of suspension or debarment. Okay, so this is the period of suspension. It basically depends on the seriousness of the grounds, and it shall continue for the duration of time that is established by the director of purchasing, unless the party is reinstated. A party can, a vendor that is debarred can apply for reinstatement. We'll go over that. As for suspensions may not exceed 12 months unless the director of purchasing commences debarment proceedings against the party during the suspension, in which, so you can be suspended and then subsequently but a party can also be debarred. So if the director of purchasing commences debarment proceedings during the suspension period essentially extends until the debarment period is over. Now you could have suspension and then debarment. You don't, and by the way, you don't have to go it's not necessary to go from suspension. A party can be debarred without having to go through suspension. But again, it's also possible to go suspension and then debarment. So if there is a suspension before debarment, the suspension period shall be considered in determining the debarment period. Finally, the director of purchasing may debar a party indefinitely if the grounds for debarment evidence willful or egregious conduct by the party. Next slide, please. And that's it. That covers the presentation, and we left time if there's any questions by vendors.
Thank you very much, Fernando. We'll invite the members of our audience. If you have any questions about any of the information that was provided by Fernando today, feel free to enter it using the Q&A feature, which should be towards the bottom of your screen. And I should add, just as a full disclaimer, Fernando is not able to provide you with legal advice or guidance, but he can speak on the various ordinances and processes that he just described in this presentation. So while we're waiting on the audience, I have a question for you, Fernando.
All
So
right.
if I'm a small business and I'm working on a contract, more than one contract, and through some fault of my doing, I end up being suspended, what happens to those contracts that I'm currently participating on? Do I have to stop working or can I continue with them?
Okay, so this was and I think we went over this in the slide. Can you go back to, I think it was number 26 or 27?
He's got it memorized.
Yeah, and it was the effect of a suspension or debarment. Can you go, I think it's before. I think we talked about it in 24, 25. Go back before. Okay, next. There we go. Okay, so look at slide number 29. So if you are suspended or debarred, you may not respond to any county solicitation. So you may not respond to any county solicitation. And I think the question was, well, what is the effect on any existing solicitations?
Exactly.
Exactly. Well, yeah. So it does not affect those. It just says right here under the code, you just may not respond to any county solicitation. So while you're suspended, the solicitation comes out. No, you cannot respond to it. But notice that the language does not specifically mention, well, what happens to the existing contract. So the suspension or debarment, it just applies to county solicitations that are kind of like, it's like prospective. You may not respond to any future any county solicitations while you are suspended or debarred.
Got it. So no new proposals, no new solicitations, but I can finish out what I've already committed to starting.
Correct.
Good to know. Not that I plan to be suspended, but all right, we're giving our audience just a little bit more time in case they have any questions. I want to mention in the chat, which is how we're communicating with you. We want you to put the question in the Q&A. But while Fernando was going through his presentation, just in case you missed it, we do have the links for the cone of silence that he referenced, as well as for the Broward County Procurement Code. And I see something in the Q&A. It says, I missed yesterday's call. Can I get a copy of that? Okay, so she missed yesterday's session, which was the first of the two sessions that the county attorney's office presented for us. Each session, similar to what we did today, will be recorded, and we're going to post it on OESBD's YouTube page, so you'll be able to see it there. Just give us a few days to get them all up and posted. We don't always have the county attorney's office present and presenting at our events. So now's a really good time. If you have questions about any of the content, feel free and enter it in that Q&A. Oh, How do we find out which companies are suspended or debarred? Well, I can chime in, Fernando, and then if you want, you can let me know if I'm on the right track. I'm aware that the purchasing division maintains a list of suspended and debarred vendors, and it's posted on their website. We'll see if we can put that link in the chat for you as well, but there is a list that I'm aware that the purchasing division does maintain. Anything to add, Fernando?
No.
Okay. All right, nothing else. I think oh, here's another. If I sell the business, will it still be debarred? So I'm assuming the rest of the context is if there is a business that is debarred that is in the process of selling that business, does the debarment follow the new company or what happens there?
And well, it's if you look here, 2170. So the procurement code says a party that is suspended or debarred. Right. So so even if you sell the company, and I'm assuming is the company going to have the same name, and it's so in other words, the company, you're just selling the company. It's the same company. The name is the same. It's just that you're selling it, and now there's just new corporate officers. Is that the question?
If the person who asked would go ahead and just comment on what Fernando was asking, if the name will stay the same, you
So
just sold it to another entity.
yeah, and let me give you an example. So let's say that it's like Acme Corporation. Acme Corporation is suspended or debarred, and then the existing corporate directors of Acme Corporation decide, okay, we'll sell the company. Can Acme Corporation still do business with Broward County? Can they respond to county solicitations during the period of suspension or debarment? Well, no. The answer is no. A party that is suspended or debarred may not respond to any county solicitation nor be approved as a subcontractor on any county contract for the duration of the suspension or debarment.
Okay, thank you, Fernando. We have another one that came in for you, and I think it
But
varies. Go ahead,
yeah,
Fernando.
no, right. But I was just going to say, right, because remember, the party suspension or debarment, if we're just talking about suspension of the Acme Corporation, or are we talking about suspension or debarment of corporate officers? Generally, it's the company that is like suspended or debarred. But just remember, keep in mind that if an individual corporate officer is suspended or debarred, um, so even if the corporate officer sells that company, the procurement code says the suspension or debarment shall extend to all entities for which the individual serves as an officer or principal. So let's say that the corporate officer of Acme Corporation sells the company, and they just but if that corporate officer is still a corporate officer of other entities in which they serve as an officer or principal, if that individual has been suspended or debarred, that suspension or debarment follows them to all other entities in which they serve as an officer or principal. But again, that's only if the individual is suspended or debarred. But I think I don't know if the question was just talking about the individual or the corporation, but if the question was just focused just on the company, what happens if the company is suspended or debarred? The debarment or suspension continues in effect, even if there's even if there's been even if the company is sold.
Good to know. And you provided both answers. I don't think I
And
was aware that it followed the officer to any future companies. That's
well,
really good to
yeah,
know.
because under there is the authority to suspend or debar. It's to any party, any quote unquote party. A party does not necessarily, usually when people think of the party, we say, oh, the vendor, the company. But a party could also be an individual of that of the company. So the answer depends on who is being suspended or debarred. Typically, it's the company that is suspended or debarred. And so if that company is sold, the suspension or debarment period would continue for the period, for the duration of the suspension or debarment, notwithstanding the fact that they were sold.
Got it. Really good information. There's another question here for you. What is the duration of the suspension or debarment? Is there a cap?
So the period of suspension, and that is in section 21.78. Oh, and by the way, if the vendors, if you want, I should have indicated the sections of the procurement code. So the suspension and debarment, that is in part 11 of the administrative code. So it's basically chapter 20, it's chapter 21 of the administrative code. And it's
We did drop the full section in the
okay.
chat, so
Okay,
they
got
have
it.
it now.
Okay. So the period of suspension, so what I think the question was, how long is the period of suspension or debarment? Is that correct?
Correct.
Okay, so the period of suspension or debarment, it basically it depends on the seriousness of the grounds for the suspension or debarment. Again, it depends on the time that's established by the director of purchasing. Under section 21.78 of the procurement code, it says suspensions may not exceed 12 months. So that's it. So a suspension can be anywhere, anywhere up to 12 months. Now a debarment period can be any length of time. In fact, a debarment period can be indefinite. The 2178 says the director of purchasing may debar a party indefinitely if the grounds for debarment evidence willful or egregious conduct. So it can be an indefinite period of suspension. Now, again, you can have a suspension cannot exceed 12 months. A debarment can be indefinite, but a suspension. So a suspension. Now, remember, even though a suspension cannot exceed 12 months, the director of purchasing has the authority to commence debarment proceedings. So in other words, the director of purchasing can say, okay, I'm going to suspend the vendor for 3 months or 6 months or 12 months, whatever. But then during that time, the director of purchasing, if the grounds for debarment are willful or egregious, they can basically do debarment proceedings while the suspension is in effect. And if that's the case, then the suspension period extends until the debarment period is over. So effectively, the suspension period would basically follow the length of time for the debarment period if it's accompanied by a debarment. But if we're just talking a straight up suspension without debarment, it just cannot exceed 12 months.
Thank you. All right, we've got some more. Does the vendor get notified if suspended?
Oh, absolutely. And there's a whole notice section in the procurement code, and that's actually I didn't go over it because just due to time constraints. But if you look at 2173 of the procurement code, it talks about the director of purchasing shall provide written notice to any party. So yes, if this is not going to happen out of the blue, the director of purchasing is required to provide written notice to the vendor regarding a potential suspension or debarment. And the notice essentially has to state the grounds for potential suspension or debarment. And this is important. It offers the party the opportunity to respond. The director of purchasing may also hold a meeting with the party to discuss the grounds for suspension or debarment if the director of purchasing determines the meeting is appropriate. And then it's only after the written response. So notify the vendor, hey, you're being considered for suspension or debarment, and then there could be the invitation to actually meet with the party to go over that. If a meeting is appropriate, or the director of purchasing could just say, hey, we're providing you notice of a suspension or debarment. Please provide a written response within this designated period, and then after that response is received. The director of purchasing would consult with the office of the county attorney's office, review the vendor's response, and then at that point they would either suspend or debar the party. But that would only be after the vendor was notified in writing and given the opportunity to respond in writing or potentially even meet with the director of purchasing.
Good to know. Thank you. We've got another question. How does Broward County learn of businesses debarred by other government agencies, whether local or state?
Um,
I'm thinking the question may be in relation to the solicitation process where there are forms that inquire about any litigation or any issues or debarments with entities when they submit a response. I'm not sure if the attendee would just qualify, but the question again is how does Broward County learn of businesses debarred by other government, local or state agencies?
and that's actually a great question. And yes, I do believe that there is in the vendor questionnaire, which is part, one of the forms that the vendors have to submit. I believe there is a question. One of the questions is, have you ever been suspended or debarred? If so, please provide the details. So I believe there is a self-reporting requirement as to whether, does the county, even if a vendor fails to disclose that, does the county have a way of knowing? I, that's a great question. I don't know if there's a offhand because I'm not involved in that aspect, but we can definitely follow up and find out.
Thank you, Fernando. There's another question. It says, what training should we take or provide to our employees to prevent similar issues in the future?
Oh, well, I believe a copy of this presentation. I mean, this is a good summary, but again, I would refer, you could, if you want to do a quick presentation, you get a copy of this presentation. And if you have specific questions, I strongly encourage you to read section 1-266, the cone, the cone of silence. Read that, and then also read the sections of the procurement code if you have more detailed questions. But if the question is, hey, how can we provide more information? Then, again, this presentation is available, is it available to Dawn Ann? Is it available to download, or do vendors get a copy of it? How does that work?
Yes, we're going to be posting it to OESBD's YouTube page and or channel rather, and it was just put in the chat by the team, the link, and that was actually the next question. Please provide the link to the OESBD YouTube page. So I think we've taken care of that. I just saw it pop up in the chat,
Okay,
so
yeah.
it's now there.
So yeah, that's a great resource. Just like watch this video. That's a very good starting point. And again, definitely download those sections of the code of ordinances and of the procurement code that I referenced. That's very helpful information.
All right. I like that answer, Fernando. Definitely use this as a tool. We want our small businesses to reference all these trainings that we've recorded for you.
Yeah, and there's also, we kind of do a very quick, like, one page, and I know this is included in all, whether it's an invitation to bid or an evaluation committee-based procurement, we give all the vendors something that we call a summary of vendor rights. It's a one-page document, but and so you look for that one-page document in the solicitations. If you just want like a one-page, cheat sheet, it gives you all the references to the procurement code. Well, for the rights to object, protest, and appeal. And again, I don't know if it references suspension and debarment. So I think that's just more for the objection, protest, and appellate rights. But definitely, if it's not covered in that page, then look for the cone of silence. Refer to this presentation, actually review section 1-266 of the cone of silence, and the other sections of the procurement code that are referenced. I would just keep those, keep those on file.
And as a reminder, the links were provided in the chat, so you can always click on them at any point during the presentation, and a window should pop up to the actual site, and you can save it to your favorites.
Yeah, and it's the reason just as an aside, the reason I spent a lot of time on cone of silence, I think this is the one that is like vendors seem to have more problems with the cone of silence than the other ones, because I sometimes like after there's like if you know if like the rankings are posted, sometimes vendors will unknowingly contact one of the EC members, or maybe they'll contact the commissioner and say, hey, I don't like what happened during this EC meeting. And I feel that we were wrongly agreed, and we're going to object. Well, guess what? You just violated the cone of silence. So just understand that's why I spent so much time on the cone of silence. It's a very important piece of of legislation from Broward County. Just understand when it starts, when the competitive solicitation is advertised. All right, cone of silence starts, and basically until the county takes action to end that solicitation, and we went through the different situations that would end the solicitation. The cone of silence is in effect, and during that time, do not contact the commissioner offices, do not contact county staff unless they're one of the carve-out exceptions, and certainly do not contact any of the EC members while the cone is in effect. And in terms of the objection, protest, appeal, we have that, refer to this presentation, the summary, one-page summary of rights, and the relevant sections of the procurement code. And just pay attention to there's 3-day deadlines for the objection, 5-day deadlines for the protest, 10-day deadlines for the appeal. Those deadlines are critical, because if you miss them even by 1 day, then you've just forfeited your right.
Definitely good information. A last call for any questions that haven't yet been asked, and then we'll run through a few additional slides just to tell you how to stay in touch with us. All right, I think that's it. I don't see any new ones. All the questions that were submitted have been answered. So just to close out the presentation, I wanted to remind everyone, by now you should have heard, it's not a secret. Broward County's purchasing division is moving from Periscope S2G, which some of you may know was formerly BitSync. We're going to a new bonfire powered system. We're calling it BPRO. And all new procurements are going to be in BPRO. For the time being, it's advisable that you register in BPRO and also register in Periscope S2G. But September, October of this year, we should be transitioning to BPRO. Any solicitations that were already in Periscope S2G will be completed that are there. So there will be a transition period that remains even once we start using BPRO. So you can use a QR code on your screen. Go ahead and register your company. It's pretty straightforward and simple. It's contact information, goods and services that your company provides. So at your earliest convenience, we strongly encourage you to do so. And if I could have the next slide, please. A benefit of the South Florida Anchor Alliance is it's a regional marketplace. Many of our small businesses are trying to find ways that they can identify upcoming opportunities from multiple sources. This is one such path. The regional marketplace is comprised of 11 anchors. Broward County government is one such anchor. So is Broward County Schools, Miami-Dade County government, as well as Miami-Dade schools. Several universities, hospitals are also members. Each of us procures on our own approximately $1 billion in goods and services each year. So you get the idea. You can see procurement opportunities from each of the anchors by using the QR code on your screen. Registration is also free. And if I could have the next slide, please. I think someone had asked, how do we stay in touch? How do we see your YouTube page? Well, we're on a variety of different platforms. We also have a business assistance weekly e-newsletter, which is generated every Wednesday called The BAW. To subscribe to The BAW, you can send an email to econdevinfo@broward.org and stay in touch. Our director, Sandy Michael McDonald, is very active on our social platforms. I joke, and I think I said it in the last presentation, that his LinkedIn following is nothing to scoff at. I think he's got more followers than everybody in the office. So stay tuned. There's always information on projects, changes in ordinances, regulations, good, useful information. And we also celebrate when our small businesses do well on contracts. I think there's also something else. Oh, Broward is buying. There is a reverse trade show that's coming up. It's Friday, August 23rd, 2 to 4 p.m. at the North Regional, which is the Broward College Library. and that's in Coconut Creek. Go ahead and register. Everything that our office does and is involved in, there is no charge to the public. So go ahead and check that out. And I also wanted to mention, I'm not sure if we have a slide for it. Oh, we do. FITCI, that's what I was going to mention. The Florida International Trade and Cultural Expo is one of two signature conferences that OESBD puts forward on behalf of Broward County. This has more of a slant on trade, international trade, and doing business with other countries. Go ahead and register, check it out. It is free to attend. It's going to be October 23rd and 24th this year. I'm not sure if registration had started yet, but it will soon. So go ahead and check us out. Thank you so much for attending. Keep an eye out. We'll be back with a new installment next year. It's a semi-annual series, so we do it twice a year. It's typically over a 3-day period, and we'll have much more new and informative content for you. Have a great day, everyone. Thank you for joining us.
Thank you.
Oh, we got one more question about Anchor Alliance, Donna Ann.
Oh, give me 1 second. Have you gotten any people noting any issues registering with the Anchor Alliance? No, we have not. But if you go ahead and I'll try to help you. If you want to go ahead and email me, send me a screenshot of whatever the issue is so that we can talk to the other members of the Anchor Alliance and see how we can best get that resolved. You can email me at DNAP, D like Donna, K as in King, N as in Nancy, A as in Apple, P as in Peter, P as in Peter, at broward.org. And I think in the chat, the main number for our office was also inserted. So feel free to reach out and we'll try to help you. Thank you so much, everyone. Have a great day.